sitting for the regular dispatch of business. The Honorable Judges, Alma Hinton, Paul C. Ridgway, Joe Crosswhite, President presiding. Oh yes, oh yes, oh yes. God save the state, this honorable court. Please be seated, remain quiet. All electronic devices should be off at this time. Good morning, Your Honors.
Good morning.
Good morning.
All right, good morning, ladies and gentlemen. We had one administrative matter we want to take up, but we're happy to hear from you. We've been thinking ahead on the schedule a little bit and also conferring with the court reporters. We know that there's been some contact with court reporters about the availability of transcripts and things of that sort. And we recognize that's going to create some difficulties. For one, Marin, the court reporter we had this past week, is on vacation this week, and so we're trying very hard not to overload her. Denise is here, and she's aware that there's some urgency in getting transcripts together. We understand that the briefs in this matter are due, assuming Friday is the end date of the trial, the briefs would be due 10 days thereafter, which would be August 5th. We as a panel would find it very helpful to also have proposed findings and conclusions of law from the parties as well, in addition to briefs. So that would be an additional request we would make of you. We're working with Marin and Denise to make arrangements to have transcripts done as quickly as possible, at least some sort of provisional transcripts or intermediate transcripts, lightly edited transcripts. I'm not sure what we'd call them. They may not be the transcripts that ultimately would be the final record in this case, but would be sufficient certainly for trial brief purposes. It may be that at least some form of transcript would be available the Friday, August the 2nd. And I know some of you are already getting daily feeds, so at least you may have some rough transcripts already. But so we're thinking that that some form of lightly edited transcript may be available by August 2nd. What we would suggest, since we've also asked for findings and conclusions, is that we push the deadline for the briefs and the findings and conclusions back to Friday the 9th rather than Friday the 5th. So that's a proposal we'd make. We'd be happy to hear from all of you about whether you see that as feasible or any other issues you want to bring to our attention about that.
So, Your Honor, we'll of course do whatever the court wants. I will say for the plaintiffs, if we can get either the intermediate or near final or sort of whatever version of the transcripts there will be by the 2nd, we can absolutely file all of our post-trial submissions, proposed findings, conclusions on the 5th as scheduled. We wouldn't need any additional time because we have roughs. We've been getting roughs. We can use the roughs to sort of populate the brief, and then it's just a matter of sort of swapping in the intermediate or final versions. Right. And obviously time is of the essence.
Yes. All right. Mr. Farr.
Thank you so much, Your Honor. Tom Farr from So, as I understand it, Your Honor, the present deadline for the briefs is August 5th?
The scheduling order says 10 days from the end of the trial, so 10 calendar days would be August the 5th.
Would it be appropriate to have everything due 10 days from the date that the transcript is available? Or at least give us another week? I heard you say August 7th or 9th, and as the court has already discovered, my mathematical skills are not all that great, but that doesn't seem to be like a full week.
Well, it moves it from Monday to Friday is what it does, so it gives a full business week from the date of the transcripts. And we anticipate the transcripts would be available Friday the 2nd in some form, and as well as there are the rough copies that are also available. And again, for trial briefing purposes, that may be sufficient.
I was just thinking, Your Honor, again, we will defer to the judge's sound discretion and wisdom of the court on this, obviously. This court is aware of how voluminous these sorts of findings of fact and conclusions of law can be in a case like this. So so, I would just ask that the court at least consider the possibility of either pushing it out 10 days from the time the transcript is available, which is a pretty standard sort of way to do this in these cases, or at least give us another week. Again, my math skills aren't great, but I think that's August 12th.
If I may be heard, we would oppose any requests for extension of time. I think it's needless. It's needless delay. We negotiated that the deadline of 10 days after the close of trial for post-trial submissions, obviously with full knowledge that the final transcripts were not going to be ready, on the day that the trial closed. I think what we're talking about, if the intermediate or near final transcripts are finished on Friday the 2nd, we're talking about people doing basically site checking work over the weekend to finalize the post-trial submissions using those transcripts in lieu of the roughs. There's simply no need for additional time.
Your Honor.
Yes.
If I could just be heard briefly on this and just to respectfully remind the court that for implementation purposes, the state board does need some lead time in order to get everything processed and to make the election happen. And the best date that they can offer is that they would really need to know what the districts are by the end of November in order to make the technology all work and get things together for the election process.
All right, thank you.
Thank you.
All right, interveners wish to be heard on this.
I think the dispute is over between Friday and Monday. We're going to rest on the court's discretion.
Thank you. All right. All right, we're gonna ask that the submissions be made on the 7th of August, which is Wednesday, so it's a couple extra days. We'll do everything we can administratively to make sure that transcripts are underway. And if there is some complication with that, we'll let you know, but we think that date should be sufficient and give us the time we need to review this matter.
Thank you, Your Honor.
Thank you. All right, Ms. McKnight.
One other issue was that we had moved in a bunch of exhibits at the end of yesterday. You're going to do it. Got it.
Your Honor, we do have a few housekeeping items, as Mr. Jones just suggested. We have two. The first relates to exhibits, and I'll describe that briefly. And the second is, I understand interveners also have a housekeeping item. So we'll address exhibits now, and then I just alert the court that interveners also have an issue. Now, we have taken the time to review the exhibits that plaintiff moved into evidence yesterday at the end of their case. We have identified some objections. At the outset, I'll tell you, we do not have objections to the majority of the exhibits they moved in. We do have objections to plaintiff's exhibits 759 through 769. And on those objections, my colleague, Mr. Farr, will present that argument to you.
All right. Mr. Carr. Thank you, Your Honor. We have two objections to these exhibits. I think if the court looks at these exhibits, it's very clear that their communications with me are addressing this objection. So we would argue their attorney-client communications. Plaintiffs are going to say that this was produced in the Dixon case. I think it was an inadvertent production on our part. I think the court ruled in that case that we'd waived our attorney-client objections. At least in Dixon v. Ruccio, we're not waiving them. I'll touch right over now. I'm sorry. It's early in the morning and I'm not speaking loud enough. I apologize. Judge Ridgway, again, this email chain is clearly communications with me, acting as a counsel for the legislature in 2011. We inadvertently disclosed them in the Dixon v. Ruccio case. The court ruled that we waived our objection. I don't exactly know all the arguments, but I'm pretty sure that that's what you ruled. We're not waiving we are not waiving our attorney-client privilege as to these documents in this case. But I do want you to know that you did rule previously that we had. But we have another objection that's more fundamental. If you read these exhibits, this email chain strictly goes to the 2011 congressional plan. There's no discussion in there about the legislative plans. If the plaintiffs will stipulate that these emails relate to the congressional plan, then we would not object to them on the grounds that I'm stating now. But if they're not going to agree to the truth of those emails, then we do object to them on the grounds of relevance, because they say nothing whatsoever about the intent or the motivations of the legislature as it applies to the legislative plans in 2011. And that's basically the substance of our objection. Thank you.
Your Honors, as to the attorney-client privilege objections, as Mr. Farr acknowledged, these emails were produced in the Dixon case many years ago. I believe there has already been a ruling by the court that any privilege was waived. I also think if you just look at the emails, there's no privileged information in them. Some of them have attorneys on the emails or even writing the emails, but there's no privileged attorney advice communications. In any event, these have been public records for many years, publicly available. As to the relevance of them, I disagree with the characterization that any of the emails relates exclusively to the congressional plan. Again, you can just go look at them. Many of them relate to the 2011 redistricting cycle as a whole. Other of the documents in that range are specifically about the 2011 State House and State Senate redistricting plans.
All right, interveners wish to be heard.
No, Mr. Chairman.
State. All right, I think we'll need to review these matters. We'll do that during one of our breaks and give you a ruling on those matters. Ms. McKnight, were there any other exhibits that you, I'm sorry, Mr. Farr, did.
I was just going to say thank you, Your Honor.
Yes, sir.
And I'll be excused. I'll be back whenever I need to go.
Yes, sir.
Collect the witness.
Thank you, Mr. Farr.
Thank you, Your Honor.
Ms. McKnight, were there any other matters you wish to be heard on with respect to those exhibits?
No, Your Honor.
Or any exhibits? All right. And so, Mr. Branch, on behalf of the interveners.
John Branch, the intervener defendant. Two items. The first one is we intended to move for the admission of legislative defendants exhibits 179 and 180, which were used in the direct examination of Connor Gross. We didn't do that meeting for this direct yesterday, but we'd like to do so now. And then the second item that we have is the plaintiffs submitted a number of deposition designations at the end of their case yesterday, and we have a couple of objections that we would like to stand on, specifically with regard to the designations from our client, Reginald Reed, and Mr. Pinkcoat was going to handle a couple of quick points on that for us, if the board would be so kind.
Yes, sir. Thank you, Your Honors. So I'm not sure which of the exhibits it is within 780 and 785.
Do you have to speak up 781?
Yes,
Thank you.
Claims to be 781 through 785. But there are particular pages and lines contained within those designations that we have certain objections to. These particular lines are related to an amicus brief filed by Mr. Reed with the Fourth Circuit related to the remand order in this action. Specifically, page 130, line 1 through 132, line 23. Mr. Reed is asked about statements made by Representative Lewis and Senator Hayes about the consideration of racial considerations in drawing maps. Mr. Reed's not a lawyer, but this seeks improper lay opinion testimony. There's also a lack of foundation for this line of question. And Mr. Reed testified in the deposition he's not a map drawer, and that he trusts the legislature to draw the maps in compliance with the law. In compliance with the law. Additionally, page 141, line 6 through 142, line 9, as well as 145, line 6, and 147, line item. Mr. Reed has asked more directly about the amicus brief filed on his behalf, which again seeks improper lay opinion testimony. Again, he's not a lawyer. I think Mr. Speed made a similar point in the redirective. Mr. Phillips, who's certainly been involved in more litigation than Mr. Reed has. And again, he's also not an expert in racial law, and so he's not qualified to testify to that.
Could you give me the page and line numbers for the 147 series?
Yeah, yes, sir. 145, line 6 through 147, line 9.
Okay, and just for the record, the Reed deposition is Exhibit 784, Plaintiff's Exhibit. Right. Okay. Did plaintiffs wish to be heard?
Very briefly, Your Honor. I'm sorry, Daniel James. I would have to go back and read the specific transcript to make my best possible argument that I could make. But I can tell you, I mean, the questions were about a amicus brief that was authored in Mr. Reed's name. It hardly seems improper to ask him about statements that were made in his name. The other thing I would note is, obviously, as your court is aware, there's a potential Voting Rights Act defense that's being put on by the defendants in this case. Mr. Reed, in that brief, was asserting a version of that defense, and so these questions, if I'm recalling them correctly, were really about whether he stands by the statements essentially that were made in that brief about his feelings about drawing, districts to have specific racial thresholds and so on. So it's directly relevant to those statements and that defense.
And legislative defendants, do you wish to be heard?
No, Your Honor.
State wish to be heard?
No, Your Honor.
All right. We'll take the matter under advisement as well, review the transcript excerpts, and if we need further input from the parties, we'll ask for it. All right. Any other housekeeping matters for the interveners? Okay. So any objection to the admission of the exhibits 179 and 180 that were proffered during Mr. Gross's testimony?
No, Your Honor.
No, Your Honor.
All right, so those are admitted. And that sounds like, with respect to all exhibits except for, at the moment, all of the exhibits that the plaintiffs identified at the close of their case yesterday are admitted except for 759 through 769, which we will get back to, and then and also with respect to the Reed deposition, which I know I just read the number, but 784, that's admitted with the exception of the lines, just pages and lines just discussed, and we'll get back to you with respect to those. Okay. All right, if there's nothing else, then let's proceed with further evidence in this case, and I believe Dr. Owen should resume receipt.
Thank you, Your Honor. Good morning, Dr. Owen.
Good morning.
I think where we left off yesterday is a good place to start. For everyone's reference, you had just testified about 2 questions you analyzed in this case, and we had started talking about the first of those questions, which was representation in North Carolina. I'd like to start with your report, and that is tab 293. It is LDTX 293. It's the first tab in your binder. And I'm focused now on the results of your analysis of political representation in North Carolina. By my view, the results of that analysis are on pages 17 through 26 of your report. Is that fair?
Yes, that's correct.
Could we start by discussing the ombudsman role of representatives in the North Carolina legislature and what you found?
So when I began the process of reviewing and looking at the ombudsman role, I initially thought about my past experience, how I had been a legislative staff member and what we did to help the members of the legislature fulfill that role. So initially I contacted the Legislative Services Commission, that division, to talk to them about what resources members of the General Assembly in North Carolina had at their kind of disposal to use to help serve constituents and voters. And in that process, I learned that members of the General Assembly are assigned or are given one legislative assistant to help them work with constituents' requests, and also to help them understand if constituents, voters call in about a particular policy area, then they would take down information to share with the member regarding how voters or constituents are viewing those particular policy areas. In that conversation, I learned that the Legislative Services Office provides the members of the General Assembly additional resources. So if the member and his or her staff need to contact and get further information to deal with a problem that a voter or constituent has, then that legislative division will work and serve that. As part of the ombudsman role, that involves casework. So if a constituent has a problem, they could reach out to their member of the General Assembly and seek some help in resolving the problem. If it's in dealing with a public agency or another governmental institution, or a situation that they need further help, then they can seek that from their member. Another part of the ombudsman role involves the ability to just speak out and contact voters and be in touch with them to make connection. And so I learned in the process of talking to the Legislative Service Division that members of the General Assembly can send a letter to a new voter. So if someone registers to vote, then the member of the General Assembly can send kind of like a welcome to the voter registration system and welcome to the district. And in that letter, there's very specific information that's been approved ethically that they can write and send to the new voter. And in doing so, they're reaching out to encourage that voter to understand that when you have this, responsibility, you're privileged to vote, but then also that they can reach out and talk to the member of the General Assembly if they have any concerns or problems that they need help with.
Let's take a look at Legislative Defendants Exhibit 164. So this is LDTX 164. It's in your binder toward the back. What is this?
This was information provided to me about what the new voter welcome letter would contain, what information would be allowed for the member to write in so that they could basically state these four things. They could thank the new voter for registering, they can inform that voter who their representative or senator is, the information to contact, how to contact that senator or representative, and then also to encourage the new voter, again, to make contact if they can be, to the member of the General Assembly if they could be of assistance in any way.
And what does this show the court?
So this is, in one way, it shows evidence that the members of the General Assembly are reaching out to voters. They're contacting, they're having a connection to their constituents. They're sending them a letter, especially those who are new voters. And it doesn't say here like which party you're affiliated with or any specific characteristics. You're just a new voter who's registering, and the General Assembly member can then welcome them as part of that process and let them know who they are so that the new voter can contact them if they need assistance.
And is this sent to all new voters or only those who support the member?
This letter would be sent to all new voters.
And now, how did you receive this letter?
In my interview with the Legislative Services Director, I asked the question in regards to is there one way members of the General Assembly can speak to their constituents where it would be a government mailed document, that would be a resource, and this was the one example that he sent me through an email. Via email, yes.
And I appreciate that this is double-sided, so it's 2 pages, but on just one piece of paper. Is the letter on the back of the page, the template letter?
Yes.
Okay. Now, I appreciate that this appears to be a 2-page template, but based on your experience, both academic and from working as legislative staff, what does this represent to you?
So the letter on the back would be an example of how the member could write the letter, the format template that they could send. The first page that we just discussed that says new voter welcome letter is from the state for the ethical compliance, so what the letter can contain so that it could be mailed on the government expense, that one piece of privilege that can be, so that it doesn't have any other information. It's just a welcome letter and the information of how to contact the state representative. But this could be used by a member's office to kind of, this example of a letter, to then write to that new voter.
So we've talked about a little bit about how a member would reach out to new voters. I'd like to turn now to how a member responds to correspondence from their voters. Did I understand correctly your description of casework earlier? Is that what this relates to?
Yes, so that would involve individuals within the district, voters, constituents. They would contact the office to ask of assistance, and then the legislative assistants most likely then are the ones answering the phone and taking down the information or answering an email request now. So they would take that information, and of course each office is different, so the legislative assistant might have an Excel file where they create and put in the information about the constituent and what the request is and what help they need from the member, and then the actual Excel file might have something that says, where the work in progress is, whereas other offices might just have handwritten notes where they're taking down information and talking to the member about how this constituent needs help in a particular matter.
And based on your experience, is this type of casework a small part of a member's job?
No, it is not a small part. It's a significant part. I think when we look at what legislators are doing, they're not only lawmaking and policy making, but part of it is really working on behalf of those constituents through casework. And also they have oversight responsibility. So in part of their work, they're going to make sure the other government branches, or especially the executive agencies, are doing what they've been tasked to do in the implementation part for policy. But casework is a significant part. And I remember in my conversation with the legislative director, when he had spoken to several legislative assistants, he said that on average,
Your Honor,
Your Honor, she's testifying about the basis of her opinions.
All right, we'll allow it under Rule 703.
Basis of experts' opinion.
So in the conversations, and from my own experience, that you can receive anywhere from 10 calls, 15 calls on average a day. And they vary as to what the constituents' needs are.
And based on your experience, do members have an interest in getting casework right?
Absolutely, they want to help and get it right. If you are helping someone in a situation, you want to make sure that the resolution is beneficial to them and helpful to them because that's one of your voters. And so you don't want to alienate them because you don't want to lose a vote, but you also don't want to alienate them to the point where they go out and talk to other family members and friends, and then you lose a host of other voters. So part of your work is to do it correctly. In my experience, I know that when we answered a call, worked with an agency to get a fulfillment of a request. So, for example, I handled defense issues in Washington, D.C., and we had a military situation. When I contacted the Department of Army, we got it resolved. That family contacted us to say how much they appreciated our assistance because they could not get any further with the Department of Army and what was needed. And so that helped us. And then as a member, we learned later that that family had contacted others to speak about the work we had done. And so, members of any legislative body, they want their work to matter and to count because they're banking on trying to run for re-election and get re-elected, and they need those votes.
And in your experience, have you ever seen, either in your professional experience, your academic experience, or your review of North Carolina, a situation where a legislative member denied casework services to a constituent based on their political affiliation?
No, I've never seen that.
So if a constituent, let's say, is trying to get their state pension check paid, can they turn to their representative for help?
Yes.
I'd like to turn now to LDTX 163. This is in your binder. Just in front of the letter, Dr. Owen.
Okay.
We were just talking about services provided to members. I'd like to ask you to explain to the court what this is.
So this is an organizational chart that shows the North Carolina General Assembly at the top, so that would be all the members, and then underneath that is a Legislative Services Commission that has staff, professional staff members who then work for the General Assembly, and then underneath that would be several other different divisions, and those divisions have very specified roles and responsibilities. So there's a Legislative Analyst Division, and you'll see within that a director and staff that can help with research requests, constituent inquiries, legal counseling, drafting of things. So this is another support arm for members of the General Assembly.
And what does this show the court?
So I think in this we see that members of the General Assembly, they have several different functions and responsibilities they have. Part of that is bill drafting and legislation, and there's a division to help them with that, as well as there is these other divisions like the Legislative Analysis Division, which could help with constituent requests. So in all the roles that they have additional resources to help them because they're one office with maybe that legislative assistant and an administrative assistant. Perhaps if they share that or have that, they can't do all the work. So this gives them additional resources and support to help them in their representative role.
And how does this compare to other states that you've looked at in your work?
So most southern states have part-time legislatures. They don't meet all year. They don't have full-time professional staffs. And so in those legislative creations of support staff, they usually have another arm, like a legislative services or a legislative division that does actually have state professional staff that work full-time to help support those needs, because they don't have an office like we would see in Congress with an office of 8 or 10 professional staff members who can help them.
What did you conclude about the constituent services provided by legislators in North Carolina?
So based on the review of information that was provided and my discussions about the General Assembly, I concluded that the members of the General Assembly, representatives and senators, are representing their constituents through a host of things involving their lawmaking and policy process, but they're also engaged in this ombudsman role. They're serving their constituents, and they're not selectively serving those who just voted for them. They're servicing anyone who contacts them in needs of assistance, because they do want to get reelected or show that they are truly representing. I mean, part of the nature is to show that you are the representative, you're the public servant for the public, and so they are working and doing that through that role.
And they have the resources to do so?
Yes.
Now, turning to a different aspect of representation, I'd like to ask you some questions about representation in the policy-making process. Yesterday, you described one aspect of that representation as descriptive representation. Could you explain that for the court?
So descriptive representation, how it's defined, would be more or less that if you're the voter, as the voter, the constituent, then your representative, you are connected to that representative because of shared experience, shared connection of your demographic characteristics. And that can be from age, your profession, your education. There's many characteristics you have, but descriptively, the representative is like you. And so you are connected to that person because you have a similar characteristic to them. They represent you because of that experience, that shared characteristic.
Now, how do you respond to the criticism that just because someone looks like me, that doesn't necessarily mean they represent my interests?
I mean, yes, just because someone, for instance, like myself, is a female doesn't mean that every woman in the General Assembly or the Congress is representing me. But as a female, I have a connection that those women actually understand what it's like to be a female. And so when issues came up in the legislative process, they are more likely to understand and espouse some type of information from that perspective. But in no way does every woman in a legislative chamber represent all women. So then it becomes particularly decisive on your values, your preferences for political policies and such.
Could we turn to LDTX? There are 3 exhibits here I'd like you to take a look at, so I'll go slowly with the numbers. The first one is LDTX 166. Let's go one at a time, Dr. Owen. What is this document?
This is a document that the North Carolina General Assembly puts out that discusses and shows the actual members and how many of each party are in the House of Representatives during this session, 153rd session, which was in 2017 and 2018. And so it classifies it by partisan of new members in the chamber, and then it breaks it down by women and African Americans and then the Native American.
And how did you get this document?
I believe this was from the North Carolina's website. And then when I did the interviews with the Legislative Services Commission, they also provided a copy to me as well.
And did you review this document as part of your analysis on representation?
Yes, so as we just discussed about descriptive representation as part of the complete concept of what representation is, I looked at this to determine and analyze how North Carolina has the configuration of the chamber for the House of Representatives and then the Senate to see how many women were serving and how many of different racial groups were serving.
Let's turn to LDTX 294. What is this document?
So this is the 154th session, a similar document where the House of Representatives, where it's a look at how many of the members are new, which party they're affiliated with, and then the number of women and those who are African American and Native American.
And how did you receive this document?
Again, this is available, I believe, on the website, and then through my course of conversations with the Legislative Service Division, they provided it as well.
And as part of your analysis of representation in the North Carolina legislature, did you review this document?
Yes.
Okay. And finally, let's turn to LDTX 295. What is this, Dr. Owen?
This document is similar to what we just seen on the House of Representatives for North Carolina, but this is the Senate's version, and it's a breakdown of the demographics of the members in the chamber. So you'll see that the new members and then those who are returning, and that's split by party, and then the number of women, and then the number of African Americans, and then there's an Indian American in the Senate.
And how did you receive this document?
Again, I believe it's available on the website for the North Carolina General Assembly, but then in conversations with the staff, they provided it to me as well.
And did this document help form your opinion and your analysis of representation in the North Carolina legislature?
Yes.
I'd like to ask you a little bit about how members represent their constituents on local issues. Could you explain that process of members representing constituents on local issues?
So members can, in the course of their lawmaking and policy work, if there is a specific local issue, then they can draft a bill, create a bill to introduce to the legislature to address a local issue if it needs to be. Also, those members of the General Assembly would work with the local county commissioners or city council members or the mayor to see if the state then can get involved with this local matter. So there's the ability for the lawmaking process to take place. And from my experience in other states and when I worked, if a local matter emerged and the state needed to help in response to it, then the members from other areas of the state would understand that at this time we need to address this local matter in community X because down the line in our community Y, another local matter could emerge, and so we need to help address each at the time. So that's kind of one way that they can get involved. Another way is that when there are local issues, sometimes voters and constituents just need a place and a time and space to actually just voice that concern to the member. So members have town hall meetings, or they're engaged with going and speaking to constituents to learn about the local matter and again see if the state needs to get involved in the legislative realm, or if there's an opportunity for just a state agency to be contacted to come in to also help facilitate some type of work in that policy matter.
Is it your opinion that there are variations of political positions within any given political party?
Yes.
Could you explain that a little bit?
So if you say you're a Democrat, within the Democratic Party, you could be a moderate Democrat, you could be a conservative Democrat, you could be a progressive liberal Democrat. There's no one ideology within one party. So there's variations. I think we see this when we hear candidates talk and we hear it in the news about, well, I'm a conservative Democrat. Well, what does that mean? That means I may have a value that's pro-life. That's getting harder maybe in some instances of our current environment to see, but there are people who would have that value but then see a host of other reasons why they would want to be a Democrat. The same as if you say you're Republican, there can be very moderate Republicans, and then there can be, really extreme conservative Republicans. So just because you identify to a party doesn't mean necessarily that your ideology is in one place of that party. You could be in different parts of the party.
And that variation you just described, in your experience, have you seen that type of variation in politics in North Carolina?
Yes.
Dr. Owen, is it possible that if you are a Democratic voter living in a district represented by a Republican, that your interests can be represented in a legislature by Democratic members from other districts?
Yes. I think it gets to the concept that we as voters have a choice when we go to the polls that we want to elect the person who most closely is like us, who identifies with our values and represents our values, but we don't always get the person that we want elected because we just don't have enough people behind that one candidate. So just because I, as a voter, am represented by someone of an opposite party than I am, or values from me, doesn't mean that the whole entire legislature is opposed to me. There is someone who probably carries similar values, similar ideology, and preferences that's also representing me there.
And based on your experience, did you see that type of effect in North Carolina?
So I think in North Carolina you have a situation where you do not have one party that has 100% of the seats. You have a division within the party, and you have the parties, and so you have Republicans who have control of seats, and you have Democrats who have control of seats, and so voters are represented by members of those parties. But just one member of one party may not align perfectly with all your values, but that within the legislature there should be people who are representing your preferences. And again, the system of government we have is that you have to have the majority of voters coming up to pick that one candidate from a single member district to support. And so even within the chamber, you have to, again, we're based off majority rule, that the majority would have to come together for the passing of legislation for a particular preference policy area.
Is it your opinion that there is geographic variation in political issues?
Yes, I mean, nationally, there are variations. I mean, we have a very distinctive study of Southern politics. So geographically, yes, there's unique preferences nationally. Here in North Carolina, we see this in other states as well, that urban voters are much more likely to support Democrats and more liberal policy areas. And when you get out into the rural areas, they have a tendency to be much more conservative, much more Republican leaning. And then now we have a conversation about what's going on in suburbia. Is it now becoming or trending more Democratic, or is it still kind of connected to the Republican Party?
And did you see that variation in North Carolina?
Yes, so when I looked, I mean, you see again that there are candidates and discussions within the parties of especially in the 2018 races where I looked at, you kind of see a nationalization. Other national prominent figures came in and discussed and supported candidates. And again, because of the idea that in urban areas, when you turn out voters, you're more likely to get Democratic, liberal voters. And then in the rural suburban area, it's this conservative, more Republican area. But then in 2018, the discussion became, would there be a blue wave through that suburban? Could the Democrats have more play in that area?
Dr. Owen, plaintiffs have alleged that Democratic voters in a district represented by a Republican member are either partially represented or not represented at all. Do you agree?
No. I would say that if you're a Democratic voter living in a district that's being represented by a Republican, Number one, you probably don't agree with everything that that Republican stands for on policy issues and areas, but you are being represented because you have someone from your area who understands your community of interest to then go speak in the legislative chamber. That's number one. Number two, you're being represented because you have the ability to contact that representative, because they're not going to ask your policy preference. They're going to ask what need of assistance you need from them, and then they're willing to work for you. And so members, no matter what party they are, they want to work for their voters, because even if you are a registered Democrat living in a district with a Republican representative, that Republican representative has on the mind that they want to get reelected, and so you, as a potential Democrat, they don't know if you're a Democrat that's extremely liberal or maybe more moderate. It might be a potential voter they could get. And so they want to work hard, and potentially you would then favor them to, again, continue to represent them.
Dr. Owen, I'd like to move on to the second question you addressed in your analysis, but before we do, one cleanup point I need to make. On LDTX 163, if you could turn to that, this is the chart that you testified about. How did you receive this chart?
So this chart is available also on the North Carolina website, but again, in my conversations with the legislative staff, they sent it to me as well so that I could understand fully the breakdown of each division.
And this chart, did it form part of your analysis on representation in North Carolina?
Yes.
Okay, thank you. Moving to the second question you answered in your report, related to competitive elections. Could you explain to the court the question and how you answered it?
So I was asked to look at the State House and State Senate elections in 2018 to determine which elections were competitive, and to determine if in these competitive elections, whatever districts they were in, if either party could win that contest. So in my analysis, what I set out to do is I took all of the electoral outcome data, so on the North Carolina website from the State Board of Elections, and I looked at every contest to see what would be deemed competitive. There's different thoughts about what really is a competitive election, but in political science, we've kind of held to a standard that through a lot of researchers and others in the field, that when we talk about competitive elections, it's within a 10-point vote margin range between the top two vote candidates. So be that 45 to 55 margin. So I went through, and the question was, in these competitive elections that would be within that margin of 45 to 55%, are they competitive? And if so, could one candidate win of either party, or a candidate of either party win?
How did you define candidate quality in running your analysis?
In looking at the elections, I define candidate quality as if a person had held prior elective office. So in this situation, if a candidate is running for the State House or State Senate, then had that candidate held any other office prior to that, and that could be a local office like county commissioner, city council member, mayor, or had they, county commissioner, city council member, or the mayor, had they held some type of prior office. That's how I use the definition. It's defined that way by Gary Jacobson and others in the congressional and legislative field. And so there's a host of ways you can define quality, high name recognition, or if you're a professional athlete, you may never have held office, but you would be considered quality because people could identify your name. But for this context and analysis, I use the idea defined as whether a candidate had held prior elective office.
Now, did you consider other aspects of candidate quality in your analysis, such as public scandals?
Yes. I mean, I looked at whether they'd held office, whether they had been involved in the community, and whether any accounts had shown any type of scandal or other issue that would have attracted attention.
Now, we heard testimony the other day from a leader in the North Carolina Democratic Party. And he testified that the way that the districts were drawn was the reason why the Democratic Party lost certain elections. In your opinion, do election results hinge on district shape alone?
Objection, Your Honor. This witness has not been qualified to answer that question. It's beyond the report that she filed, and we object.
Ms. McKnight?
Your Honor, there are pages and pages in her report about the results of elections in North Carolina and what they say about the competitiveness of those districts. As I've said, we've heard testimony from a leader of one political party saying that competitiveness was harmed because of the way the districts were drawn. We have proffered Dr. Owen as an expert to talk about the competitiveness of elections. Plaintiffs have been on notice of that opinion since she served her report.
Your Honor, there's not a word in her report with regard to the question of whether or not candidates have lost their elections because of lines. I think this is well beyond the scope of her report. She examined various elections and looked at issues like candidate quality. Nowhere in her report does she look at whether or not elections are outcome of elections is influenced by district lines.
That's not my question. Pardon me, Mr. Spees, are you finished? I didn't mean to interrupt you. Your Honor, her opinion is not about the way the district lines are drawn. The question I asked her was about whether election results hinge on district shape alone. Again, she has throughout her report, and she's testified here today, she will testify that elections are much more complicated than that.
What methodology does she?
The professor used to analyze whether shapes of districts contribute some, none, or completely to the outcome of elections.
The analysis she uses is based on her experience as a political scientist to opine about elections, the results of elections, whether they're competitive or not, and that they involve a variety of different factors, that it is not, election results are not related to one item alone. And that was the question I was asking her. Your Honor, I can rephrase my question.
Well, the question, in your opinion, does election results hinge on district shape alone? That seems to be a question that begs some sort of analytic response. I mean, if you're looking for a general opinion about a laundry list of things that might shape an election, I guess that might not take a rigorous evaluation, but to the extent you're attempting to quantify the degree of influence that a election district shape may have on the outcome of an election, that seems to be something that would require a methodology that needs to go through Rule 702 Daubert analysis.
I understand, Your Honor. Let me rephrase my question to get at what we're interested in. Dr. Owen, are elections complicated in how they result?
Yes.
Okay, how so?
So elections are very complicated, and there are many variables that affect the outcome of an election. So they're complicated in the fact that it hinges on how many voters turn out, the candidates, candidate quality, campaign resources, funding, the messaging issues. Election outcomes can be affected by the context of what's happening nationally and in the state. There are many things that affect election. It doesn't hinge on one thing alone. It's very difficult to pinpoint that an outcome is on one thing.
Now, before asking you about your analysis of competitive elections, I'd like to understand how you went about conducting that analysis. What references did you use to analyze competitive elections in North Carolina?
So when I started this process of analyzing the competitive elections, again, as I mentioned earlier, I went to the State Board of Elections and looked at all the elections and defined and found all of the contests for the State House and State Senate that fell within this margin of 45 to 55%, this 10-point vote margin. And then I also relied to understand the actual outcome of contests that fell within this range that are deemed competitive here. I then utilized newspaper reports, and I utilized other sources from North Carolina, so the public policy kind of watches and the blogs, to then actually kind of understand what was happening leading up until the November election. So in a district where two candidates are competing, and if you're looking at it now, several months after the election, it's hard sometimes to find the candidate's website. They can, especially if you lose the election, you're likely to pull that website down pretty quickly. So I relied on the newspaper reports, some television reports too, and if I could find a campaign advertisement, then I would look at those to determine kind of factors that would have gone into the election to see if that could have had some sway in the actual ultimate outcome. So for candidate quality, to determine if somebody had held elective office before, the newspaper accounts, usually a local paper will talk to both candidates and then give a profile of that candidate. So I use that to determine if they'd ever held office or if they were a community leader, because they'll talk about that in those profiles. And then for campaign resources, which I also use to kind of understand in this race how one candidate compared to the other and fundraising and expense, I used the North Carolina's campaign disclosures and all of that information and went through the data files to find out how each candidate, how much money they had raised, where the money had come from, and to get an understanding of what resources were available in the race. And then I would just kind of, again, through newspaper accounts, read about what issues were messaged and discussed in that local election. So I really tried to rely on the local paper in those areas of districts that I identified.
Let's start. What did you conclude about competitive elections in North Carolina?
Your Honor, I object. This person is testifying as an expert based upon her reading of some newspaper articles. I don't believe there's been any basis established for this person to testify as an expert about any aspect of North Carolina politics. She's testified that the opinions she has expressed here are based on reading newspaper articles. We don't know which, we don't know when, we don't know where. There's no suggestion that she has done any survey. There is no suggestion she has looked at any polling data. She has testified herself she never talked to a voter. She's testified herself she never talked to a candidate. So we believe, Your Honor, that this would be an improper question of this witness.
Sure, Your Honor. Now, first, as to the which, when, where, Dr. Owen has submitted an expert report in this case. As you can see, it's heavily cited to newspaper reports and other sources. Dr. Owen has testified that her opinion is not based solely on newspaper reports, that it is based on her experience that, as we told you yesterday, involves over a decade of working in Southern politics, focused research and writing on North Carolina specifically, and teaching research methodology for years in different locations. Dr. Owen is an expert in Southern politics. She has done work on North Carolina. She knows how to apply research methodology to understand the political science issues going on in this state. And finally, She has also testified about the value of newspaper articles. I understand that plaintiff's counsel would like to dismiss the value of newspaper articles, but she's just testified about why those are important resources for a political scientist to review and understand before they form their opinion.
And I would just observe that the document in front of you, this report, establishes that this witness has taught one course in North Carolina and in Southern politics about 3 years ago at a former institution. I don't believe that that in any way qualifies her or adds to her qualifications to talk about North Carolina elections and politics.
We're going to overrule the objection. I think the objections go to weight, not admissibility, so we'll allow the testimony. Thank you.
Thank you. So, Dr. Owen, let's start with what you concluded about competitive elections in North Carolina, and then we'll delve into your analysis.
So based on my analysis and looking at the elections that I was able to put into this definition of competitive, there are significantly strong showing of competitive elections in North Carolina. So either party, both party has an opportunity to win because the state, some of these elections were with less than 2% of the vote variation and vote margin. And so either party has an opportunity to successfully campaign and win in these districts. I also find that in these districts and in our elections, we see here in North Carolina that candidate quality matters. So when you are running for office, it does help if you're running for the state house or the state senate to show that you have experience by holding another office. Voters can trust that you know how to be a public servant, and so they're more likely to support you. So candidate quality. Also, we know, I mean, in North Carolina, we see that the parties, and we see this nationally too, parties have a lot of money at their resources. Candidates are generating a lot of enthusiasm. They're able to raise money, but money doesn't always mean you get more votes. And so you may outraise and have a lot of money at your disposal, but that doesn't translate always into another vote coming your way. So part of my conclusion is that campaign resources matter, but it doesn't mean that you're always going to win. It shows that there's support from your party to you as a candidate, and that you can actually then turn those resources into actually messaging, but you have to do that strategically and effectively. So part of taking your campaign resources is using it effectively and strategically to message to voters, turn out voters, and get them to support you. So in these elections, I determined that there are a host of factors going into the outcome. It's candidate quality. It is partisanship in a way, so voters are going to vote and align with their parties. It is about resources, and it is about the context. I mean, 2018 is a unique year in the fact that you had a lot of national buzz even into state races. So those all come into play. But here what I see is that in North Carolina, you have a lot of division and close races that are competitive, where one party, either party could be, if they put in the right candidate, put in the right resources, could actually win those districts.
And now looking at your report in LDTX 293, your analysis of competitive elections in North Carolina, does it appear on pages 6 through 17 of your report?
Yes.
Let's first focus on your analysis of the North Carolina House elections in 2018. I'd like to focus on pages 11 through 13. I see an analysis that you ran on House district elections in HD 19, 51 and 63. I'd like to ask you first, on page 11, this is the first full paragraph on that page. About midway through the paragraph, it looks like you write, also there has been growing divisions. Do you see that sentence?
Yes.
Does this address the urban-rural divide you were describing earlier today in your testimony?
So this is part of the paragraph where I talk about how political climate, the context, many things are affecting candidate decisions and campaign strategies. And also we see that there has been a growing division along the urban-suburban rural split. And so that then affects how the parties are recruiting candidates, how the parties are able to influence with resources into those areas, and then ultimately that will affect the outcome.
Now turning to page 12, I see your analysis of those 3 House districts you were just describing. Could you tell the court in summary whether you found candidate quality issues in each of these House district races?
So these are the state House races, and there were, I believe, 25 competitive races. And in those, there was variation between candidates challenging incumbents versus an open seat. And in these 3 contests, you had Democratic challengers challenging Republican incumbents. And so candidate quality did matter. So if we look at the race of District 19, which is the first one up there, which is near the Wilmington area, you had a 3-term Republican incumbent, and he was being challenged by a political newcomer who had not run before. She was able to outraise the incumbent, so she had a lot of money at her disposal to use for resources, but again, and had issues to address in the campaign that maybe were seen as vulnerabilities for the incumbent. And what I hear again, the vote was extremely close. So the incumbent won, but with less than 1,000 votes. And so in this situation, I think we see one, candidate quality is at play, as you asked, because you had a political newcomer running, someone who did not have experience running before for an office and holding office that they could have discussed with voters. And then 2, you have the power of incumbency here. So you have a 3-term Republican incumbent, and with incumbency comes advantages that you can talk to your voters about.
And what did you find in State House District 51 that affected the competitiveness of that election?
So again, we see that this is a Democrat challenger facing a Republican incumbent. This is near, District 51's near, I mark here the Research Triangle, and you had an incumbent Republican who had been seen as moderate because in the early 2000s he had supported a Democrat. This Democrat had supported a Democrat for the co-speakership in the General Assembly. Had supported the co-speakership for the Democrat in the General Assembly. The Democrat candidate in this contest was again a political newcomer, had not held office before, was not, by how I defined it, a quality candidate. She had been a small business owner, community leader, but again didn't have the experience of running a campaign. She did outraise the incumbent. So again, we see an infusion of money into these races, and we see too, again, a close vote margin. So the Republican incumbent was able to win, but with less than 1,500 votes, and so that's a smaller vote margin where a Democrat with a quality candidate could have challenged, again, this district. But again, I think we see the incumbency advantage here where that incumbent could speak about the things that they had done to represent the district.
And in your experience, is it unusual to see an election where an infusion of money does not overcome the lack of experience of a novice a candidate?
So yeah, you can have a novice candidate, a newcomer, raise a lot of money and still not be able to win the contest. And a lot of it's just the candidate appeal. I mean, it gets to a host of factors. Does the candidate appeal to the voters? Does that candidate have the ability to get out to their voters and mobilize them? It's not just about money. I mean, I'm from Georgia. The most expensive special election race just happened where a candidate raised over $30 million to the other candidate's $6 million and could not win that race, couldn't bump their vote percentage at all.
Do incumbents tend to have an advantage over newcomers to politics?
Yes. So in political science scholarship, we've been looking at congressional races, state house, state senate races for decades, and we see that incumbents, their rate of success is over 90%.
And going into the next election, will current members have a certain incumbency advantage?
Yes. So those who are serving right now, when the next election rolls around, if they're the incumbent, they choose to run, they're going to have that advantage. They have a record to speak on. They're utilizing opportunities to connect to voters, to already speak to them over the 2 years of what they're doing. So voters are going to be aware of them and know their name because they are the current member.
And the next election will be a presidential election year. Do presidential election years have a different voter profile than off-presidential year elections?
Yes.
Your Honor,
So
objection, this is not a part of our report.
This one, no.
Your Honor, her report talks about the variety of factors that go into elections, making them competitive or not. She talks about turnout. I'm asking her opinion about turnout in the next election.
Sustained.
Dr. Owen, does turnout vary across election years?
yes.
Let's turn to your analysis now in the Senate. Now, as I see your report, your analysis of competitive elections in the Senate the results of your analysis appears on pages 13 through 17. Is that fair?
Yes.
Dr. Owen, I see that you've analyzed a variety of races in these pages. I'd like to pick one as an example for you to illustrate for the court parts of your analysis. On page 16 of your report, I see an analysis related to Senate District 24. Could you talk to the court about your analysis of candidate quality issues in Senate District 24's race in 2018?
So this paragraph has two races, one that's Senate District 24 and one that's District 39. And so in District 24, you see that you had a contest with the Republican majority whip, and you then had a Democrat, a young Air Force veteran attorney who is challenging him. In the second district, and again, you see the quality of the candidate where the Democrat had not held elective office before, challenging a Republican incumbent. In the second district, in District 39, which was south of Charlotte, you had again, the Republican, an incumbent member being challenged by the Democrat. And in this Democratic primary, so before we even get to the general against the Republican candidate or the Republican incumbent, you had a sociology professor challenging a CEO tech, and strong candidates, but neither had held elective office. And then the tech CEO, he wins the primary and goes on and challenges in the general election, and the Republicans found out about this drinking while intoxicated charge that the Democratic challenger had in the previous 10-year span, and they ran messaging on that. And so this kind of shows that if you have some type of issue that could call into question your integrity or character, then that can affect then how well voters are attracted to you, trust you to actually be their representative. And so it plays out that in these campaigns, there's a lot of things going on between messaging, candidate quality, the style of the candidate, what they can do. Even though you can raise a good amount of money, you have to be able to appeal to voters.
I'd like to turn now to some criticism that has been lodged against your opinion in this case. Plaintiff's expert Dr. Cooper, in a rebuttal report, has criticized you for reviewing more elections than he deemed relevant. What is your response to that?
So my opinion is that when we're doing research on elections, more data, more elections help you to understand the full scope of what's going on. I don't think it's right, I don't think it's methodologically sound to go in and cherry pick select elections that you can work with. So that's why I defined competitive election in that standard kind of that we use in political science, that 55, 45, 10-point vote margin, and then I included all of the elections that I could see in 2018 that fit within that. And then some of those elections, the margin was even less than 5%, and I looked specifically at those. Some elections were less than 1%. And so that is very competitive. And again, kind of detail a little bit more of that in some of the analysis. But in what I chose, it was to state all of the elections that fit in here, this definition, not just ones that I think could be discussed.
What about the criticism that you did not interview all voters, so you cannot possibly understand whether people are represented or not? How do you respond to that?
So there are polls that you can look at, and they can have the discussion of what's being represented, but I think given the time constraints that I was asked to write the report, it would have been very difficult for me to launch my own survey and poll people, just to spend time contacting and doing that type of polling analysis to speak to each voter in the state about if they are or not being represented. But the analysis on representation, we've done that in the political science field for years, and we rely on political philosophy and scholarship to talk about the notion of representation. And then we do talk about it through this lens and framework I talked about descriptive representation and substantive representation. And in that, I built the analysis that here in North Carolina, it's similar to what we've seen in other states, and we know theoretically that people are being represented because that's the type of governmental system we have.
And based on your experience working and teaching with research methodology, is it your opinion that the fact that you did not interview a number of voters or launch your own surveys, that decreases the reliability of your conclusions in this case?
No, I don't think it decreases that. What I've put forth is what I was asked to do and talk about, which was the concept and the assessment of what representation is. And from my knowledge experience, not only in the academic world, but professional world, I know what representation looks like. And I know that voters have and are represented by people in different ways through their legislative process and the legislative branch. They are being represented. to have talked to each voter, as I do with talking to students each semester, you get a host of answers if they even know what the legislative branch is compared to the executive branch. And we're talking college students. So the perception is that if you were to poll all voters, that they're going to honestly give you an answer. Yes, from what they know. But I don't think that it would have changed what I have opined about. And I think it speaks to the fact that the conversation here is about, are they being represented? And we see that they are.
Let's turn briefly to LDTX 165, please, Dr. Owen. What is this?
This is a document that I worked on, and it was sent to me and then I worked on, that contains all of the legislative measures, bills that were introduced in the House in the session, in the latest General Assembly session, and it was the bills that were passed and became law. And then it was broken down by the party of who voted yes or no for the actual passage of the bill.
What about, and did this form part of your analysis in this case?
Yes.
What about the criticism that your analysis did not focus on hot topic, controversial bills?
So in part of this analysis, what I was looking at is whether there was bipartisan support in passing legislation at the General Assembly. And so I just looked to see, of all the measures that were there, were Republicans and Democrats supportive of so many measures. Not picking hot button topics was not part of understanding whether bipartisan support is there. Any controversial public policy is going to have a partisan division. That's kind of why we have two parties in the American political system, is they have opposing opinions on policy. And so with those topics, you will see a division. So there are bills in there that you do not see the bipartisan support, and there are bills in here that would be deemed non-controversial, but that shows that in representation, not everything is controversial. Sometimes, as being a representative or a senator, you have to pass legislation that recognizes, that changes some type of policy that's not controversial, that everyone can be in support of, because it's doing a public good. It's providing a service or a need that the state may have.
And Dr. Owen, I'd like to conclude with two questions for you. Plaintiff's expert has critiqued you for including in your research information that is difficult to confirm. What is your response to that?
So the information that I've provided in my report, newspaper articles or any citations are there. You can go in and confirm. Some of the campaign websites have been taken down. As I mentioned earlier, when candidates lose, they don't want to pay for the website anymore, so it does pull down. So access can be changed at that point, which is another, difficulty when you want to talk to a candidate and their website's not available anymore. You don't have contact information to reach them. But as far as what is presented in my report, the references are there, and those citations, you can find the information. It can be substantially looked at and cross-referenced and checked.
And in your opinion, based on all of your experience, is political representation a mathematical equation?
No. Representation, it can't be quantified into numbers. You can collect data to understand how many women or how many African Americans are serving in the legislature. You can quantify how many bills are passed by one party, but you can't quantify being represented or quantify that a member is always working to represent you, even if you haven't contacted them. I'm a political scientist. We study political phenomena, social phenomena, behavior. That is not something that's always quantifiable. Sometimes we just have to look at what's being reported by the people and speak to them at the time to understand what actually is happening in this phenomena time.
Thank you, Dr. Owen. No further questions.
We'll take a break.
Until 10 minutes till 11, and we'll resume at that time. Cross-examination, Mr. Spees.
Yes, thank you, Your Honor. Good morning, Dr. Owen. Would you put your academic credentials in front of you, please? I think that's Exhibit 293 in the notebook in front of you, and I believe it begins on page 28 of that exhibit. Is that correct?
Yes,
This is current?
yes, except for yesterday I mentioned that I had won the 2 research grants.
And it's accurate?
Yes,
And you're currently,
Microphone, is your microphone on? Just show green light.
yes, it does.
you are currently an assistant professor at the University of West Georgia in Carrollton, Georgia.
Yes,
You do not have tenure at the University of West Georgia, correct?
no,
Before that, you were an assistant professor at Reinhardt University in Alpharetta, Georgia, correct?
yes,
You did not have tenure at that institution?
I did not. I was on the tenure track. I'm on the tenure track at both institutions.
But you've never acquired tenure at any institution of higher education?
No,
On direct examination, you talked some about your experience as a public health and legislative analyst, am I correct?
yes,
And I believe you were engaged in that employment for a period of 10 months, 15 years ago, is that right?
yes, almost 15 years ago.
And you also talked to some degree on direct examination about your experience as a legislative assistant. And that was for a period of 15 months, about 15 years ago, correct?
Yes,
Now, beginning on page 29 of your academic credentials, you list your publications, correct?
yes,
Is it correct that you have no publication dealing with North Carolina politics?
I do not have a peer-reviewed publication.
Do you have any peer-reviewed publication dealing with North Carolina elections?
I'm trying to, so in my book on women office holders and the role models who pioneer the way, I look at state legislators who run for higher office, and I look at all the state elections and state legislators. So there would be North Carolina state legislators listed in that data, and I would look at, and I examined whether those women who had served would want to run for higher office.
So other than the possibility that in a book you might have mentioned a North Carolina politician running for public office, you have no publication concerning North Carolina elections, correct?
In my book, there is information. I'm sorry. In my book, there is information on North Carolina legislators, and it examines elections data. I do not have any publication that specifically addresses North Carolina.
And you do not have any publication concerning representation in North Carolina?
I have not written on North Carolina.
The next topic in your academic credentials is on page 30, and it's current research and working papers, correct?
Yes.
Your current research and working papers do not include North Carolina politics, do they?
The special elections book to the U.S. House covers all special elections from the 1940s, and so that is a book project I'm working on with a co-author, and so we look at entire elections and special elections. There are incidences where we have examined North Carolina, but I don't recall, I mean, it is not a specific book on North Carolina special elections, but it examines elections in all of the 50 states for those going to the House.
In North
The
Carolina?
working paper on voter identification, these co-authors and I have been examining different voter identification laws, and so we're examining all these different laws in different states.
Let me ask the question this way. Your current research and working papers topics do not include any paper or project focusing on North Carolina elections.
No.
And your current research and working papers do not include any focus on North Carolina politics.
These projects have states, and North Carolina would be included, but they're not focused specifically on North Carolina.
And your current research and working papers do not include any focus on the topic of representation in North Carolina, correct?
These works, again, are focused on different issues, but we don't focus specifically on North Carolina.
The next part of your academic credentials is entitled Conference Participation. That's on page 30, is that correct?
Yes.
Is it correct that you have never participated in a conference focusing on politics in North Carolina?
I'm not aware of a political science conference focused solely on North Carolina. We do have regional conferences and state conferences, but I've attended like the Southern Politics Symposium, and those panels, we cover all the southern states.
So you have never participated in a conference focusing on North Carolina politics?
I've attended the Southern Symposium, and we cover North Carolina in that, but there's not a specific North Carolina conference.
Is there a focus on North Carolina at that conference?
Sometimes we have state panels, so we specifically look at a state, North Carolina, Georgia, we can attend those panels.
Have you ever participated in a conference focusing on representation in North Carolina?
Again, as I just answered, at the conferences I've attended on the Southern Symposium, we talk about Southern politics, we talk about representation issues, elections, voter information. There's a host of different ideas that we discuss, and it's regarding any Southern state can be discussed.
The next topic in your list of academic credentials is invited presentations. Is that correct?
Yes.
Have you ever been invited to a conference to speak about North Carolina politics?
No, I've not.
Have you ever been invited to a conference to speak about North Carolina elections?
No.
Have you ever been invited to a conference to speak about North Carolina representation?
No, I have not.
Have you ever been interviewed by any North Carolina media outlet about North Carolina politics?
I have not.
Have you ever been interviewed by any media outlet about North Carolina elections?
I have not.
Have you ever been interviewed by any media outlet about representation in North Carolina?
No, I have not.
Do your academic credentials also list the courses you have taught?
Yes.
And is that on page 32?
Yes.
And is it accurate that the courses you have taught, is that a complete list of courses?
It does not include, I'm sorry, hold on. It does not include everything that I taught this past spring of 2019.
Did you teach Southern politics this past spring?
No.
Is it accurate from your academic credentials that you have taught a course in Southern politics once in your career?
I did teach it once at Reinhardt, and I was hired at West Georgia, and we have another scholar who also teaches Southern politics, but we can only offer courses when they're demanded, and right now it is not a topic that's being demanded by our students.
So once in your academic career, you have taught a course in Southern politics, and that was 3 years ago at Reinhardt University, correct?
Yes. Yes.
Dr. Owen, one of the two topics you address is representation in North Carolina, correct?
Yes.
And representation involves examining the relationship between members elected to the legislature and the persons who put them in office, the voters, correct?
Yes.
Now, in preparing your report to this court about representation in North Carolina, you did not talk to a single North Carolina legislator, did you?
No, I did not.
You did not talk to a single former North Carolina legislator, did you?
No.
You did not talk to a single North Carolina voter, did you?
I did not speak to let me back up. I spoke and had conversations with staff members at the Legislative Services Commission. I assume they're voters, but we did not have conversations about how they voted.
So other than two staff members at the North Carolina legislature who you believe are registered voters, you did not speak to any voter in North Carolina about their representation by members of the legislature, correct?
I did not, and as I mentioned earlier, given the time constraint and what I was asked to do with representation, that was not part of the process that I was able to fulfill.
Okay. Now, you did not review or identify any survey of citizens regarding their views about their representation, did you?
In my report, I have not included survey information.
And you did not review or use any polling data regarding the views of citizens about their representation in preparing your report, did you?
In this report, I did not cite any polling information.
And in your analysis of representation in North Carolina, you found that there's a legislative staff and each member of the legislature has an assistant, correct?
Yes.
Would you please turn with me to, let me get this correct, I believe it's page 6 of your report. I'm sorry, it's page 5 of the report. On page 5, at the bullet near the bottom third of the page, do you express your opinion with respect to representation in North Carolina?
Right, the last bullet, I'm sorry, it's.
First bullet.
I'm sorry. Yes, that's my opinion.
And would you read into the record the first sentence from that bullet?
Residents and voters in North Carolina are not egregiously harmed when their respective representative does not descriptively mirror them or.
If you're gonna just read it slower, respectively, does not.
Descriptively mirror them or substantively act for their partisan preferences and interests.
So it's your opinion that North Carolina residents and voters are not egregiously harmed?
Yes, that is what I've written.
Okay. What does egregiously mean? Extreme?
I would characterize it as shockingly, surprisingly.
So your opinion is that North Carolinians are not excessively or extremely harmed by the representation they receive from legislators, correct?
That is what I've written.
And you stick by that?
I have written that. That's what's in my report. I think they are not harmed when that representative is not descriptively mirroring them or substantively acting for their partisan preferences and interests.
Let's turn to your second topic, which I believe is competitive elections, correct?
Yes.
Now, in preparing that part of your report, you did not talk to any legislator, correct?
I did not speak to any member of the General Assembly.
You did not speak to any former legislator, did you?
No.
You did not speak to any winning candidate at the last election, did you?
I did not speak to candidates.
You did not speak to any losing candidate at the last election, did you?
As I just said, I didn't speak to candidates.
You did not speak to any voter.
As I mentioned previously, I discussed and spoke with staff at the Legislative Services, who I presume are voters, but I did not speak to an individual voter.
You did not consult any polling data.
No.
You did not consult any survey data.
I've referenced the materials that I use for the elections in my report.
And thank you for bringing that up. If you would turn with me, please, Dr. Owen, to page 5 of your report, specifically footnote 10 at the bottom of the page. And would you read that into the record, please?
All references and sources of information used in my evaluation and analysis are presented in footnotes. Additionally, these sources are used to inform my analyses and opinions regarding North Carolina.
Okay. Is it accurate, Dr. Owen, that the most commonly cited source of information for you in developing this entire report is something called Real Facts North Carolina?
I would not say that I relied on Real Facts North Carolina for most of this work. This work in my report shows has several citations and a lot of different sources. As I mentioned earlier, there's newspaper references, there's political scholarship, but it is one of the sources.
Well, let's separate your citations to articles in journals. I'm looking for the information, the facts that you used in preparing this report. Isn't it accurate that the single largest source of information or facts you used in preparing this report is something called Real Facts North Carolina?
I did use Real Facts North Carolina, but I would not characterize it and say that it's the source I relied on for all my facts, because or most of the facts. I have used other newspaper accounts as well as candidate information that I could find from websites or advertisements to use to learn about these elections.
My question was whether Real Facts North Carolina is the most often cited of the sources for this report.
I would have to count up each citation and determine if it was.
And that's followed by newspapers?
Yes, that we're covering these elections.
Okay. So, all of the opinions that you have expressed in this report are based on your reading of something called Real Facts North Carolina and some newspaper articles, correct?
My opinions are based on my knowledge, my experience, my expertise, along with these reports from the Real Facts North Carolina, as well as newspaper reports that were covering the elections and the discussions of what was happening at the time.
Dr. Owen, a part of your analysis of competitive elections involves the classification of candidates as quality or not quality candidates, correct?
Yes.
And if you would turn with me to page 12 of your report, is it accurate that in preparing this report for the court, you classified a U.S. Army colonel as a non-quality candidate?
Yes, because my definition, as I mentioned earlier on quality, defines it as a dichotomous. You've either served in prior elective office or you haven't. A U.S. Army colonel has not been elected to public office.
And is it also correct that you classified a small business owner and community leader as a non-quality candidate?
Yes, because according to that definition, that individual had not held prior elective office. This is a dichotomous measure whether you've held the office, some prior office, or you had not. As I mentioned earlier too, quality candidates can be defined by others in different ways. And so for some, they may presume that you have high name recognition, then you're quality because you've been a pastor in the largest church in the community. But that is not how in political scholarship we have defined and use that as our mark of measure. And so I went with what has been in this field and what we use as that definition.
Now, Dr. Owen, you testified, I believe, that in your view, North Carolina legislators are providing constituent services to both Republican voters and Democratic voters alike, right?
Yes, I believe that they're being represented.
And I believe you testified that legislators should not and do not discriminate against voters on the basis of their party affiliation in providing constituent services, correct?
It is my understanding from my knowledge and discussions that they do not.
Then I'd like to ask you this question. Would you agree with me that the General Assembly of North Carolina should not discriminate against voters on the basis of their political beliefs and party affiliation in drawing districts?
Objection, Your Honor. This goes well beyond her expert report and her testimony on direct. Your Honor, in addition to that, it's a legal conclusion.
Overruled. May answer.
I'm sorry, I didn't hear you.
Overruled, you may answer.
Could you ask it again? I'm sorry.
Yes. Would you agree with me that the General Assembly of North Carolina should not discriminate against voters on the basis of their political beliefs and party affiliation in drawing district boundaries?
I believe that any representative or senator should not discriminate against voters because of their partisan beliefs, no matter what the issue is. They should not discriminate against people.
Thank you. No other questions, Your Honor.
Cross-examination from interveners?
Yes, sir.
From the state? Redirect from the legislative defendants?
Your Honors, no redirect. I do have an administrative issue to handle.
All right, yes, ma'am.
I'd like to move in exhibits. I'll talk slowly with the numbers involved. We would like to move in for admission LDTX 293 to 295, as well as LDTX 163 through 166. These materials are in the binders in front of your honors. They include her report and data or information supporting her analysis.
Any objection, Mr. Spees, to these exhibits?
Your Honor, as I understand it, you have determined that my concerns about her credentials go to the weight and not the admissibility, but with that observation.
Any objection from interveners? All right. So we'll be allowing the admission of all of these exhibits. Again, the report is admitted for corroborative purposes. The other exhibits are admitted substantively. Very good. Thank you.
Thank you, Your Honor.
Further evidence for the, thank you, ma'am. I'm sorry. You might step down. All right. Further evidence for the legislative defendants.
Thank you, Your Honor. We'd like to call Dr. Janet Thornton.
What was your name?
Thornton. Thornton.
Please remain standing. Place your left hand on the Bible and raise your right. Do you solemnly swear that the testimony you're about to give this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. You may be seated.
Yes, it's Janet R. Thornton, Thornton.
Dr. Thornton, have you prepared an expert report for this case?
Yes.
Could you turn to tab 1 of your witness notebook? Could you let us know if that's a copy of your expert report?
Yes, it is.
Could you turn to appendix, I believe it's appendix A, and would you let us know if appendix A is a copy of your curriculum B-type?
Yes, it is.
Thank you, Dr. Thornton. And can you, for the court's benefit, describe your educational background?
Sure. I have a PhD in economics and a master's degree in economics from Florida State University. I also have a bachelor's degree in political science as well as economics from the University of Central Florida.
Dr. Thornton, you're doing really well so far, but the court reporter here has a very hard job, so let's both of us make sure that we speak slowly so she's able to get what we're saying.
Okay.
What is your occupation?
I'm an economist and applied statistician.
How long have you worked as an economist and an applied statistician?
For nearly 35 years.
Can you describe your professional experience as relevant to this case?
Yes, professionally, for nearly 30 years, I worked as an economist and applied statistician at Economic Research Services, or ERS, in Tallahassee, Florida. A few years ago, I moved on to another firm, Berkeley Research Group, where I currently hold the title of Managing Director.
And what's the name of the new firm?
Berkeley Research Group, or BRG.
Can you tell the court what BRG is?
Sure, it's a research firm that's a global research firm that prepares research, analyses, studies for governmental entities involving matters for related to private entities, universities, as well as individuals on a worldwide basis.
Dr. Thornton, what does your experience entail?
So, my experience involves preparing studies that often involved statistical analyses involving these very same entities. And I am asked from time to time to testify in federal or state court. Sometimes and often I prepare proactive studies for entities, and in addition, I sometimes publish regarding some of my research.
Could you tell the court, do you have any experience with computer programming?
Yes, since the early 1980s, I've been preparing computer programs on many different computer platforms. They've changed over time, trust me. And I've written code and reviewed code in many different programming language and software.
Give the court some idea of the size of the data files that you have worked on and the projects that you've been involved in your career.
Sure. Some of the projects involve a relatively small number of observations, 100, 200 observations. Some of my projects have involved billions and billions of observations that I've analyzed.
And how does your experience relate to the issues in this case, Dr. Thornton?
Well, here, as with other projects, I'm preparing research, I'm reviewing information, I'm reviewing statistical concepts and statistical techniques and preparing them myself.
And have you taught statistics?
Yes. Occasionally, I am asked to teach statistics and quantitative methods. But my primary role is that preparing analyses privately.
Are you a member of any professional organizations?
Yes.
Could you tell us what they are?
Yes, I'm a member of the American Economic Association and the National Association of Forensic Economics.
Have you published in any peer-reviewed articles?
Yes.
Publications?
Yes, I've published in the Journal of Legal Economics, the Journal of Forensic Economics, and I wrote a chapter, co-wrote a chapter in the anthology Development in Litigation Economics.
What type of statistical analyses have you prepared as a professional? Could you provide some other specific examples?
Sure. In a voting context, I have calculated, for example, the voting participation rates by race to determine if they're statistically different. In the employment case, I prepared disparate impact analyses to determine if there are statistically speaking differences by race, gender, ethnicity, age, for example, in hiring or promotion or termination, depending on what the question, or pay.
Are you familiar with the term binomial test?
Quite.
And can you tell the court what that means?
Sure. The binomial test is a test that's used when you have two possible outcomes. So it's binary. For example, you're electing a Republican or a Democrat. Are you hiring someone, yes or no? It's a yes or no question. But it's particularly relevant when you have proxy data, when you have incomplete or not accurate information.
Could you give the court a little bit better explanation of what you mean by proxy data?
Sure. When you do not have complete information, accurate information, then you're using a proxy. So I'll give you an example. Suppose that a state did not collect race information on voter registration. So one doesn't know then what is the racial composition of the registered voters. So the question then is, well, what information can we do to approximate it, to proxy it? And in that case, often one would use, for example, voting age population data, so it's limited to the voting age, and use that as a proxy measure for that voting registration. There are could be other measures, but I'm using that as an example.
Dr. Thornton, today your testimony and in your report, you used the term statistically significant. Can you tell the court what you mean by that?
Sure. Generally speaking, when outcomes are outside of 2 standard deviations, they're referred to as being statistically significant. And a statistically significant outcome, then, those outside of 2 standard deviations have a probability of occurring by chance of 5% or less.
And can you explain to the court your experience with the binomial test?
I've used it for 30 plus years. For example, in disparate impact cases, they're often used to determine whether there's statistical support for an allegation of discrimination.
Did you say what kind of cases, for example?
Disparate impact.
Dr. Thornton's microphone turned on. Dr. Thornton, just try to pick your voice up a little bit for the court.
I will try.
Thank you. How does your experience relate to your assignments in this case, Dr. Thornton?
Well, in this case, I am reviewing the underlying data. I'm reviewing the assumptions that are being made. I am reviewing the outcomes, and I'm determining how different are those outcomes for each of the 3 experts who have prepared simulations.
And have you been qualified to testify as an expert on these topics in prior cases?
Yes.
Have you prepared analyses of this nature for cases involving allegations of discrimination?
Yes.
Could you elaborate?
Yes, I've been asked, as I've testified before, to determine if there is statistical evidence related to whether or not there is statistical support for an allegation of, for example, discrimination on the basis of age or race or gender or ethnicity.
Have you testified in any voting rights cases?
Yes.
Could you explain those to the court?
I've testified in matters involving the states of North Carolina, Virginia, Ohio, and Arizona.
Have you ever been excluded by a court from testifying?
No.
Could you tell the court briefly what your assignment was in this case?
I was asked to review the reports of Dr. Chen, Dr. Mattingly, and Dr. Pegden. I was asked to review the underlying information, in this case, the elections that they used, and their underlying assumptions and a criteria that each used in deriving their simulations. I was then also asked to determine if what they've derived from their simulations in terms of the estimated number of Democratic seats that each generated, how they compare to what they estimate for the enacted map.
How does your training and experience relate to what you have prepared in this case, Dr. Ford?
I'm doing the same thing I do for other projects. I'm reviewing the underlying information. I'm reviewing computer programming logic, like I have many, many times before. And then I am reviewing the assumptions and testing those assumptions, and then providing statistical analyses.
Your Honor, we'd like to now offer Dr. Thornton as an expert witness in the fields of economic and applied statistical analysis.
Any objection?
No objection, Your Honor.
Anyone else? Interveners in the state? No, Your Honor. All right. All right, her testimony will be received as proffered.
Thank you, Your Honor. Dr. Thornton, I'm going to ask you to summarize your findings for the court. Have you reached any conclusions about the elections used by plaintiff's experts?
Yes, I have concluded that the elections that the three plaintiffs' experts have chosen have influenced their outcomes.
And have you reached any conclusions about the criteria used by plaintiffs' experts?
Yes, I have concluded that the assumptions that they've made and the criteria that they have applied have influenced their outcomes. As a researcher, when you program, whether it's a simulated map or anything you program, you can influence the outcome by the criteria and the assumptions that you program.
Finally, Dr. Thornton, have you reached any conclusions about the seat share predictions made by the plaintiffs' experts?
Yes, I've reviewed their reports and have determined that the seat share depends on the seat share difference that is computed depends on the election. The seat share difference ranges from 0, depending on the election, up to about 5 for the Senate and, for the House, and approximately 2 for the Senate.
All right, so Dr. Thornton, I want to ask you a question about elections used by plaintiffs' experts. Would you turn tab number 2 in your witness notebook? And Dr. Thornton, this is a report. I'm going to ask you to explain it, but is this particular chart found in your expert report?
Yes.
And can you tell the court what this is supposed to represent?
This chart lists the year of the election, the contest, and the Democratic vote share, assuming 2 parties, which, if you review, ranges from a little 43.9% up to over 60%. And then it shows the elections chosen by Dr. Chin, the elections chosen by Dr. Mattingly, and the elections chosen by Dr. Pegden. I've also added 4 asterisks because in a 2-page appendix to Dr. Pegden's report, he provided some analyses for those 4 other elections.
Dr. Thornton, why does it matter what election each plaintiff's expert uses?
Well, the election that you use to evaluate the simulations and compare it to the enacted map will impact the seat share difference that is being calculated. And so it can have a bigger difference or a smaller difference depending on the election that is being used.
All right, and just for the record, Your Honor, the chart that we have just looked at, we would identify as Thornton demonstrative one. Let's turn now to tab 3. And I want to ask you, Dr. Thornton, can you provide an example of how the elections chosen by the expert influenced their analysis?
Sure. So Dr. Mattingly, in his report, provides some really good examples of this. And so this demonstrative is taken from Dr. Mattingly's report. And so in the first column, he lists the 17 elections that he used to evaluate his simulations. And then the next column provides the median number of Democratic candidates that he estimates based on his ensemble. And Dr. Mattingly just refers to his simulations as his ensemble. So, for example, if we look at the very first row for the U.S. Senate election in 2010,
Can we highlight that, please?
Dr. Mattingly estimates from his simulations 15 Democratic Senate seats. And I should have been clear, this is regarding the Senate. And he used the median number of seats across the simulations. And the reason why he used that is because the median, which is the middle value, if you were to rank all of his simulations and the number of Democratic seats that he's estimating, he's taking the middle number. And the usefulness of that is it is then not going to be influenced by extreme outliers. So that's his choice of using, as I understand it, the median. And then the next column is the number of Democratic seats estimated using the U.S. Senate 2010 election for the enacted map. So for this first election, U.S. Senate 2010, there is not a difference between that which Dr. Mattingly calculates from the simulations and that which he would have estimated for the enacted map. So you can see that that's the case for the first two elections, the 2010 U.S. Senate and the governor election for 2012.
So explain the columns across the top of this chart so it's clear for the court and for the record.
Sure. So the first is the election. The next column is the median number of Democratic seats estimated from the simulations. The next is what Dr. Mattingly estimates as the number of Democratic seats using that election for the enacted map. And then the next column is the difference between that which he estimates from the simulation and that which he estimates from the enacted plan. And then the last column is the percentage difference of the seat share, seat shift difference that he calculates as a percentage of the number he estimated from the simulations.
Okay, so just to make it clear, Dr. Ford, under Dr. Mattingly's simulations, the median in his ensemble for both the U.S. Senate 2010 race and the governor 2012 race is identical to the number of seats that he predicted would be won under the enacted plans. Is that correct?
That is correct.
And then Dr. Mattingly made this chart, not you. Is that correct?
That is correct.
Okay, can you tell the court, if we go to the bottom of the seat shift column, there's a number that says R, I think it says plus 2.244. Can you explain to the court what that is?
Yes, so that is overall, if you were to average the seat shift differences that he's computed, he averages that across these elections, there were basically 2.24 more Republican seats or 2.24 fewer Democratic seats from the enacted map on average compared to his simulations.
All right, and then a question of interest to me is what did Dr. Mattingly report? Let me rephrase that. In your opinion, what was the main election that Dr. Pagden relied upon in his report?
The main election that Dr. Pagden relied upon is the Attorney General election for 2016.
And what did Dr. Mattingly report for the 2016 Attorney General election in Thornton Demonstrative 2?
Dr. Mattingly estimates for the Attorney General election in 2016 that the simulated map would have estimated 3 more Democratic seats relative to the enacted map. So the enacted map has 3 more Republican seats than what the simulations would have generated.
And I want this to be clear to the court. Do you recall that Dr. Chen has testified that he used the 10 elections that were relied upon by the General Assembly that took place from 2010 to 2016?
Yes.
Did Dr. Mattingly use those elections?
He used those elections plus 7 additional elections.
And we'll get into that in a little more detail later. Now, let's turn to tab 4, which is Thornton Demonstrative 3. Now, can you tell the court what this is?
Yes. When Dr. Mattingly prepared his rebuttal report, he corrected this table. So this is an updated version of that which is in his original report.
So this was not prepared by you, this was prepared by Dr. Mattingly, is that correct?
That is correct.
And Dr. Thornton, are there any significant changes between Dr. Mattingly's first version of this chart, which we labeled as Thornton Demonstrative 2, and his corrected version, which we labeled as Thornton Demonstrative 3?
There are some changes which then influence his overall average. So, for example, while the U.S. Senate 2010 election result does not change, for the governor election in 2012, Dr. Mattingly now estimates that the enacted plan would have generated one more Democratic seat relative to his simulations.
I'll stop you right there to make sure I understand. So are you saying that Dr. Mattingly predicts that the 2017 Senate plan would actually elect one more Democrat than the median number for his ensemble using that same election?
That's correct.
Are there any other changes on that chart that are significant?
Yes, if one goes back to the prior chart, one can see that the largest seat shift difference is 4, and that's for the U.S. Senate contest in 2014. And when we look at his corrected chart, the same election, that seat shift difference is reduced from 4 to 3.
And I may have missed this, Dr. Ford. What about the seat shift average at the bottom of demonstrative 3? Does that change?
Yes, so the seat shift difference on average across the 17 elections for his original chart was 2.24 Democratic seats, and based on his revised chart, the seat shift difference is on average 1.94 seats.
And could you tell the court how the elections relied upon by Dr. Pagden fared under Dr. Mattingly's corrected chart?
Yes, the seat shift difference remains at 3.
And what about the other elections that Dr. Pagan relied upon?
So the other 4, which would have been the lieutenant governor election for 2012, it's 2, a seat shift difference of 2. The presidential election, which is for 2012, which is a seat shift difference of 2. The U.S. Senate, a shift of 2014, has a seat shift difference of 3. And then the governor's election for 2016 has a seat shift difference of 2. So generally, the other few elections that Dr. Pegden included in his 2-page appendix had a lower seat shift difference than the Attorney General election of 2016.
Okay. So now let's turn to Dr. Mattingly's chart for the House. I'd like for you to flip to tab 4. I think it's tab 5, Your Honors. This is Gordon Demonstrative Exhibit 4. Can you tell the court what this is?
And this is from Dr. Mattingly's report, and it shows what he calculates for the House. Again, for each of the 17 elections, calculating the median number of Democratic seats estimated from his simulations, the Democratic seats estimated for the enacted plan, and then the seat shift difference.
Okay, and I just want to point out a few things. Dr. Gordon, in his House chart, what does Dr. Mattingly report the seat share being when he used the United States Senate election for 2010?
For the U.S. Senate election for 2010, Dr. Mattingly estimates that the enacted plan would have resulted in 3 more Democratic seats than his simulations.
And what does he report for the 2012 governor race?
Dr. Mattingly estimates that there would have been 4 more Democratic seats resulting from the enacted plan as compared to his simulations.
So this is similar to your testimony on the Senate, where even under Dr. Mattingly's analysis, depending upon the elections used, the enacted House plan actually performs better for Democrats than the medium plan in Dr. Mattingly's ensemble. Is that correct?
Yes, it generates more Democratic seats from the enacted map.
All right, and can you tell the court what Dr. Mattingly shows for the 2016 Attorney General election relied upon by Dr. Pegden?
Dr. Mattingly reports a seat shift difference of 6 seats. So based on his simulations, he estimates 50 Democratic seats as compared to the enacted plan of 44 for a difference of 6.
And what does demonstrative 4 show that Dr. Mattingly calculated for the other elections relied upon by Dr. Pegden?
For the lieutenant governor election, Dr. Mattingly reports a seat shift difference of 2 seats. For the presidential election for 2012, he reports a seat shift difference of 3 seats. For the U.S. Senate in 2014, a seat shift difference of 2 seats. And then the governor's election in 2016, he shows a seat shift difference of 4. So in each of those instances, the other elections have a smaller seat shift difference than the Attorney General election for 2016.
All right, and I think we've already covered this about Dr. Chen used the 2010 to 2016 elections, and Dr. Magley added some elections.
Yes.
Is that correct?
Yes.
Now, what is the overall median average difference in Democratic seats between the enacted map and the simulated maps prepared by Dr. Mattingly for House districts using all 17 elections?
Okay. Based on all 17 elections, Dr. Mattingly calculates an average seat shift difference of 3.35 seats.
All right, let's turn to tab 6. And we're now looking at Ford demonstrative 5. Are you there with me?
I am.
And this is the chart that's in your expert report?
Yes, it is.
Okay. Now, down at the bottom, the chart is broken up into two sections, one on the left and one on the right. Can you tell the court what the section on the left represents?
So the section on the left is a replication of the chart that we just reviewed together, and it just doesn't contain the percentage that was the last column. So it replicates where we have an average seat shift difference of 3.35 seats.
So just to be clear, on the left of demonstrative 5, you're replicating Dr. Mattingly's own chart that we've showed the court as demonstrative exhibit 6. Is that correct?
That's correct.
And that shows a difference, average seat share difference of 3.35 using the 17 elections used by Dr. Mattingly.
Yes.
Now, Dr. Ford, the elections that were not used by Dr. Chen, but used by Dr. Mattingly, how many of those elections were from the 2008 election cycle?
6.
And do you recall that was a pretty good year for Democrats in 2008 when President Obama was elected?
I vaguely recall that. I'm not a political scientist, but I do recall that.
But that data is over 10 years old at this point in time, is that correct?
Yes.
So Dr. Chen, you'll recall, made a big point about it was important to use the elections actually relied upon by the General Assembly.
Yes, he did.
If you take out the elections that Dr. Mattingly added and only used the elections that Dr. Chen said should have been looked at and the elections that the General Assembly actually used, how does that change Dr. Mattingly's analysis?
Okay. The average that Dr. Mattingly calculated of the seat shift difference, the average seat shift difference is reduced from 3.35 seats to 1.5 seats.
To what?
1.5 seats.
So just to be clear, if you take out the 2008 elections and there's one more that Dr. Mattingly used, he's predicting that the enacted House map will only result in 1.5 more Republican seats than the median number for his entire ensemble. Is that correct?
Yes, he's stating that on average, if you remove those elections, he would calculate an average difference of 1.5 seats.
And Dr. Corbin, is this a good example of your opinion that the elections you use have a great impact on the analysis that you make?
Yes, as we can see from just looking at the column of the differences, there's substantial variation from a -4 up to a +11, depending on the election, and that average is reduced from 3.5 to 1.5, depending on if those other 7 elections are included.
Okay, Dr. Thorpe, can we turn now to Thornton demonstrative 6, which is 9 tab 7. Now, could you tell the court just in general, I may ask you some specific questions, but what exactly is Thornton demonstrative 6?
It's the same information that we just looked at for the House, but now it is for the Senate. So the first 4 columns are a replication of what Dr. Mattingly reported for the Senate in his updated chart. And then the last 3 columns are the results if you had removed the elections that were not included by Dr. Chen or part of the legislative criteria.
Without going into all the detail, how did removing the 6 elections from 2008 and the other election Dr. Mattingly used, how did that impact the difference between Dr. Mattingly's median for the Senate ensemble and what he predicted for the enacted Senate map?
The average that Dr. Mattingly calculated of 1.94 is reduced to 1.8.
Now I want you to turn to tab 9. And we've identified that as Thornton demonstrative 7. So, is this report, is this chart demonstrative 7, is this in your report?
Tab 8.
Tab 8, yes, sir.
Yes.
All right. Now, does this explain the impact of Dr. Pegman's focus on the 2016 Attorney General election?
Yes, as you can see by looking at this chart, the average Democratic share, vote share, that's calculated from the 10 elections that would have been included by Dr. Chen, the 17 by Dr. Mattingly, and then the key elections by Dr. Pegden, results in a very different Democratic vote share. And as we could see from the prior charts, the Democratic vote share that's being used and applied to these simulations impacts ultimately the estimated number of seats.
All right. Now, we're going to move to another topic, Dr. Ford. Your second conclusion is that the assumptions made by the plaintiff's experts when generating their simulated maps influence the outcomes. Why do you say that?
Here we have, just as with other instances, people are writing computer programs. And the computer itself isn't going to derive a neutral outcome. The computer is going to do exactly what the analyst or the research is programming the computer to do. So if one is applying a set of assumptions or applying a set of criteria that drive those outcomes, they will basically obtain the desired outcome. So as a researcher, you can obtain an outcome that you may be seeking based on how you program that computer logic.
Is there an old saying that kind of summarizes that, Dr. Ford?
Well, I think of it as garbage in, garbage out.
Can you explain to the court your understanding of how Dr. Chen's algorithm worked in drawing districts?
Yes, and I'm going to refer to my report to give me the details. So what Dr. Chin does is he will take, for example, a county cluster, and depending on the expert, some refer to it as a county cluster, some refer to it as a county grouping. But he will pick a spot in a county grouping, and then he will grow that map. To grow the map and to come up with the map, he uses a variable called a T-score. It's something he designed, and that T-score drives the maps that he then is selecting.
Can you explain to the court how Dr. Chen uses this T-score?
Yes, so the T-score is basically just a mathematical formula. It has addition and multiplication in it. There is nothing special about the name T-score. It is what he refers to it in his computer logic. But the T-score has an element for VTD splits, municipality splits, and then he takes that and he takes the value of 1.75 and he subtracts from that his REOC and Pulpsy-Popper compactness measures that he calculates. So he designed this function. And then he uses that, and he is, by using that, looking for those maps with the lower score. So he's designing his algorithm to choose maps with a lower score. That then drives what he ultimately selects.
And does this procedure limit the number of maps that Dr. Chen's algorithm will generate for a county group?
It definitely does. It basically is going to, in some instances, just keep selecting the same map repeatedly.
Could you have changed this T-score to allow for a wider variety of maps?
Sure, there's an infinite number of ways in which one can design a formula to basically select the maps. He could have modified.
I think this is the material that's been excluded and the motion to eliminate is undisclosed.
I don't know that, Ron. I don't think that that's true. What was excluded was her chart, which explained the unique maps for all county groups, but she's never been excluded from testifying about how Dr. Chen's T-score works, and in fact, she explains this in her report. Furthermore, Dr. Chen gave extensive testimony at trial about, he admitted that his maps result in a limited number of unique maps, and this is merely responding to Dr. Chen's testimony, and it's also elaborating the testimony that's in Dr. Thornton's report. We're not attempting to reintroduce the charts that we put up that show the number of unique maps in all the county groups.
Yes.
Mr. Ron, if I may, first of all, it's not responding to Dr. Chen's deposition testimony. His deposition testimony is not evidence. His testimony is what he gave on the stand. They had a deposition testimony at the time the court considered the question of whether or not to allow testimony about the unique number of maps, and the court decided to exclude those. So the deposition testimony is irrelevant. It wasn't in her report. The court properly excluded. She shouldn't be allowed to testify about the unique number of maps. If she wants to testify about the T-score in the abstract, I'm not going to object to that.
I'm not talking about his deposition testimony. You heard his testimony where he admitted that in the Franklin Nash group, he only drew 5 unique maps. And Dr. Thornton did talk about, in her deposition, the way the T-score worked. She wasn't asking any questions about what the results were. She didn't ask the question about how the T-score worked, and she refused to answer it. That'd be one thing, but she was not asked that question. All that was excluded was her summary of Dr. Chen's actual data showing exactly the number of unique maps that he calculated.
Regarding my last point, when the court allows was the witness's ability to testify about it, and that's why we're raising it now. We have no objection to any cross they wanted to raise.
I believe that the expert, Dr. Thornton, has testified that by using a broader T-score or a differently defined T-score would result in a different number of unique maps. I believe that is a general proposition that's been stated. The charts identify the number of unique maps prepared by Dr. Chen and then purport to quantify additional maps that could be, my recollection of the charts is a little limited, that purport to quantify the number of alternative maps that could theoretically be possible is the nature of the charts that we excluded.
Your Honor, just to clarify, and it's confusing. So my understanding of what you excluded was that Dr. Thornton took Dr. Chen's data and ran his data and provided charts that showed how many unique maps Dr. Chen actually created for each of the county groups. That's my understanding of what was excluded. Now she's just testifying about how the T-score works, and he's admitted in front of this court that he produced a limited number of maps in the Franklin Nash group, and that's fairly interesting, Your Honor, because he doesn't say that in his report. So I think Dr. Thornton should be allowed to pursue this testimony so long as she does not get into the part that was excluded, which is telling the court what the total number of unique maps per county group are.
Yeah, I think we're going to allow the testimony. Dr. Chen certainly testified about why maps were, why a limited number of unique maps could be created in certain county groupings, to the extent that Dr. Thornton believes that the formula employed to create the T-score has an impact on that. I think that opinion would be admissible.
Thank you, Your Honor. So, Dr. Thornton, have you reviewed Dr. Chen's trial testimony in this case?
Yes.
And did he not testify that that his algorithm only created 5 unique maps for the Franklin Nash group?
Yes, that's what he testified for the House.
And how does that compare to what Dr. Mattingly did for the Franklin Nash group?
Yes, in his rebuttal report, Dr. Mattingly calculated that there were, using his assumptions, 139 unique maps.
Thank you. Now, could Dr. Chen use another formula to compute the T-score variable and still satisfy the criteria he used?
Sure. There's an infinite way of generating maps.
Could he have changed the value of the T-score as one example?
Sure. He could have used, for example, a value other than 1.75. So it could have gone higher or lower. That would have then impacted his T-score value. He could have added a random element. There's many different ways of modifying the T-score so that you are then being less restrictive in what you're selecting.
And what would have happened to the simulations if Dr. Chen had used a different T-score?
You would have a different set of maps.
What is the impact of Dr. Chen's method which restricts the number of maps that he is considering?
By restricting the number of maps, you're removing the variation. And when you remove the variation in the number of maps, you're more likely to have a statistically significant outcome, and that is always the case.
If a different T-score measure had been used, how would it have impacted Dr. Chen's conclusion that the inactive maps are an outlier?
You would have had a different set of maps. If you had more maps, more variation in maps, then you are reducing the you're reducing the chance of outliers, and you are lowering the likelihood of a statistically significant outcome. So when you increase variation, you are lowering the chance for a statistically significant outcome.
All right, so I want you to go back and explain to the court again what you mean by removing variation.
So when we think about a range, for example, of Democratic seats, if you have a range, hypothetically, of 45 to 50 seats, that's limited variation in a smaller range. On the other hand, if you have more variation so that you have a wider distribution, a wider range, you're increasing the variation. When you increase that variation, you are lowering the likelihood of a statistically significant outcome.
All right. Now, could you tell the court what you use a term, I think, compliant map?
Okay.
What does that mean?
A compliant map would be the map that meets the legislative criteria.
In your opinion, did Dr. Chen follow the legislature's criteria for compactness?
No, he's using a T-score to derive the maps that he's then using.
Did Dr. Chen follow the legislature's criteria on divided BTDs?
Only in the sense that he's limited it after using the T-score.
And what about the legislature's actual criteria on municipalities? Did he follow that?
Again, it's only after applying this T-score.
So did Dr. Chen's, were his simulations compliant with the General Assembly's criteria?
Not to the extent that he was relying on the T-score, which he was.
Did this influence the number of Democratic seats that he then estimated from the simulations?
Yes.
Could you elaborate?
So if you are restricting the number of maps and you're restricting based on this very limited criteria, you're going to limit, it's going to influence ultimately the outcome.
So you could have more or fewer predicted seats from both parties, is that correct?
You could. It could go either way.
And what opinions can you express about Dr. Chen's analysis regarding statistical significance?
Again, because he has removed variation, I'm of the opinion that he has so narrowly defined what he's selecting that his outcome is not reliable.
All right, now let's turn to Dr. Pegden. Can you tell the court what you think Dr. Pegden did for his simulations?
So Dr. Pegden started with the enacted map, and then he moved VTDs using the Markov chain Monte Carlo simulation approach for basically moving around VTDs.
And how many maps did Dr. Pegden generate?
I believe he estimated approximately 2 trillion maps, but not all of those would have been compliant.
Dr. Ford, just to give the court an idea, how many maps could you actually create from North Carolina? How many maps could be created from the state of North Carolina?
It would be a number that none of us could even fathom. It's huge.
Now, Did Dr. Pegman's algorithm cover all the possible redistrictings that would satisfy the legislature's adopted criteria?
No.
And how do you know that?
Well, one, he testified about that and stated that he had not.
Can we turn to tab 11? Are you there, Dr. Ford?
Yes.
Do you recognize this pages from Dr. Pegman's deposition?
Yes.
I'm going to read the question starting on line 13, and then you're going to read the answer on 16, okay? So here's the question, Dr. Pegman. So you're not then comparing the enacted districting against all possible districtings that satisfy the 2017 legislative criteria, correct?
And
what is his answer?
Dr. Pegden responds, that is correct. I think I stated that in multiple places in my report.
Okay, thank you. Now, what can happen if Dr. Pegden does not cover all possible areas that would satisfy the legislative criteria?
So you will end up having, you will not have the full information. Again, you're removing variation. And one can think about it as such. And this may be a simple explanation, but you're moving around the map just as though, suppose your home was the map and you lost your keys. And the only place you were looking for your keys was in your bedroom. But the keys were actually in the garage. And you just kept focusing on the bedroom. You're going to miss finding the keys in the garage. What is meaning by this is, with these approaches, you can get stuck in certain areas of the map, just as you're stuck in the bedroom looking for the keys. And you're not then going to consider all of the area that you could have looked for or found the keys. So are we generating, or is he generating, all compliant maps? No.
Now, Dr. Ford, did Dr. Pegden follow the legislative criteria of the enacted plans?
No, he did not.
So, for example, how did Dr. Pegden deviate from the criteria with respect to population?
He states that, quote, I require comparison districtings to have district populations within the same range as the enacted House or Senate plan, respectively. So he's not applying the criteria, he's just saying, how does it deviate from the enacted plan?
What was the actual criteria, Dr. Ford, if you remember?
It was to be plus or minus 5% from the ideal.
How did Dr. Pegden deviate from the legislative criteria found in the enacted maps with respect to the concept of compactness?
So the legislative plan or the legislative criteria had that for the district, that the compactness measures of the REOC score or Pulpsy-Popper would meet at least the minimum thresholds, and that was to improve upon the prior plan, as I recall. Instead, Dr. Pegden focused on the Pulpsy-Popper score and not the REOC score, and he also made a variation of the way in which he measured that Pulpsy-Popper score. so he deviated from the criteria.
Did Dr. Pagan evaluate compactness for any specific district?
No, he did not.
What did he do instead?
So instead, he averaged it. So you could have one district with a very low score and another one with perhaps a very high score, and it would average out to then meet a threshold.
Did Dr. Pagan make any adjustment for incumbency?
No.
What are the effects, if any, of Dr. Pagan using different criteria than the criteria actually followed by the legislature in the enacted plans?
He's going to derive a different set of maps.
I'm sorry, I didn't hear you.
He will end up having a different set of maps.
And what could happen to the political leaning of his simulated maps when he doesn't follow the actual criteria used by the General Assembly?
His simulations could be more or less Democratic or Republican.
Did Dr. Pagan's choice of elections influence his conclusions?
Yes, and I believe I spoke to that earlier. His primary focus is the Attorney General election of 2016, that if we look at Dr. Mattingly's results show a bigger seat difference than the other elections.
So just to be clear, the election that Dr. Pagan used, which he primarily focused on, is the election that Dr. Mattingly shows as having the biggest plus Democratic difference between Dr. Mattingly's ensemble and the enacted plan.
Yes, for the 10 elections.
Now, let's move to Dr. Mattingly. How did he do his simulations?
So Dr. Mattingly starts with an approach similar to Dr. Chen, where you're finding a spot in a county grouping and growing the map. The approach he uses is to do that is the same approach as Dr. Pegden, so which is the Markov chain Monte Carlo simulation approach. So he's sort of using part of Dr. Chen and part of Dr. Pegden's combination.
Does Dr. Mattingly's ensemble cover all possible maps that comply with the legislative criteria?
No.
Did he say anything about that in his deposition?
Yes, he testified as such.
Can we turn to tab 12, please? Dr. Ford, you recognize this as the transcript of Dr. Mattingly's deposition?
Yes.
All right, I'm going to read the question that starts on page 19, and I want you to read the answer through, it's line 19 on page 104, and we're going to go through page 105, line 5. Okay, I'll read the question and read the answer, all right?
Okay.
Are there critics, aren't there, that say that the MCMC does not uniformly sample from the full set of feasible maps, right?
And he states we're not trying to uniformly sample, we're sampling from the score function.
So I get it. So you're not trying to uniformly sample from all possible maps. You're only trying to sample from the maps that meet your scoring function.
He states correct.
All right, thank you. Now, continuing with Dr. Mattingly, what happens to his conclusions when his ensemble does not cover all possible compliant maps that could have been drawn?
Again, he will not have all possible maps, so it could be more Republican or more Democratic if one had all of the compliant maps.
And would the enacted plan be representative of Dr. Mattingly's ensemble?
if you included all possible maps, then yes,
But he doesn't include all possible maps, right?
that's correct.
So just on the ensemble he included is the enacted map representative of Dr. Mattingly's ensemble.
If one had included all compliant maps, then it would have been included in that in his ensemble.
Okay, but the ensemble that we have is the representative map, is the enacted map representative of the actual ensemble that Dr. Mattingly has produced in this case?
Well, he's not applying all of the criteria as the legislature applied them.
Did Dr. Mattingly follow the legislative criteria that the legislature adopted for the enacted plans?
No.
How did Dr. Mattingly evaluate a simulated map?
So, as he testified at his deposition, Dr. Mattingly designed a scoring function to evaluate each of his moves in his chain, and he applies constraints. So his scoring function includes a weight for population score, Pulpsy-Popper score, and a municipality score. So he scores that, and then that impacts which simulated maps are considered.
And how does Dr. Mattingly score population?
So he scores it to the ideal. Rather than using the plus or minus 5%, he's scoring it to the ideal.
And just to be clear, Dr. Thornton, can you explain to the board what you mean by ideal?
Sure. So if you had a population of 100 people and you had 10 districts, then the ideal would be 10 in each of the districts.
All right, thank you. How does Dr. Mattingly's compactness measure deviate from the legislature's criteria for compactness?
So he ignores the REOC score that was part of the legislative criteria and focuses on the Pulpsy-Popper and then assigns a score to it. So he's not applying the minimum thresholds that's described in the legislative criteria.
And did you say that he ignored the REOC test?
Yes, he did.
Does Dr. Mattingly deviate from the legislature's criteria on municipalities?
He has a different description of how he weighted municipality splits, and I'm going to quote what Dr. Mattingly stated in his report. He describes his municipality score function as a measure of how many people in a given municipality have been separated from the districts that best represents their municipality. So he's designed a score for that.
Is there anything in the legislative criteria that defines the municipality criteria that the legislature actually used? Has anything even remotely close to what Dr. Mattingly used?
As I understand it, the plan was to, or the criteria was to have fewer precinct splits than the prior plan.
Okay, and I was asking about municipalities.
Oh, that they could be considered was in the plan.
Now, to Dr. Mattingly, tell the court what you mean by weights.
So he's weighting.
Let's explain weights first, and then I'll ask you to follow up.
Sure. So if you have a function, you may want to weight, for example, population more so than a municipality split versus compactness. You may want to weight one factor more than another. So as a consequence, depending on the weight, you'll come up with a different value to evaluate a plan, a map.
By the way, is there anything in the legislative record or criteria that indicates that the legislature gave specific weights to any of the criteria that they used?
I'm not aware of that.
Now, does Dr. Mattingly apply uniform weights for each component, for each county group?
No, he does not.
Could you give an example of that?
So, for example, for population, he does not apply a consistent threshold or plus or minus 5%. Instead, he says in some instances he could not do that. So, for example, for the Wake House cluster, he used plus or minus 12%.
So for the Wake House cluster, Dr. Mattingly used a population measure that's inconsistent with what's legally required in the state of North Carolina. Is that correct?
Based on what he stated in his report.
Now, what is the impact of the deviations by Dr. Mattingly on the simulations?
Well, it impacts ultimately which maps he's going to select as part of his simulation ensemble.
If you use different criteria, would you get a different ensemble?
Yes.
What happens to the political leaning of simulated maps when the actual criteria adopted by the legislature is not consistently applied to the simulation versions?
Again, it could be more Democratic or more Republican, depending on the set of maps that are derived.
Did Dr. Mattingly control in any respect for the incumbency election?
No.
Did Dr. Chen, Pagan, or Mattingly control for the legislative criteria that the committees may make reasonable efforts to ensure voters have a reasonable opportunity to elect non-paired incumbents of either party for a district in the 2017 House and Senate plans?
No.
Would it have made a difference had they controlled for this part of the criteria?
Yes, they would have a different set of maps.
Dr. Gordon, now I want to move to the last part of your testimony about your conclusions as they relate to the differences in the Democrat House and Senate seats of the enacted maps and the simulated maps based upon these three experts. What is the average seat difference that Dr. Chen calculated?
Dr. Chen calculated for the House, on average, a seat difference of about 4.5 seats, and for the Senate, about a little less than 2 seats.
So just to be clear, you're comparing what Dr. Chen predicted for the enacted map versus what in the simulations?
So it's the number of Democratic seats. So he estimates from his simulations on about 4.5 more Democratic seats based on the simulations as compared to the enacted map, and he estimates on average a little less than 2 more Democratic seats based for the Senate based on his simulations as compared to the enacted plan.
I want to clarify that you're comparing what he predicts for the enacted maps to the average for his simulations, is that right?
Yes.
You're not talking about the bottom end of his range.
That's correct. It's the average that he reports.
And what is the average seat difference that Dr. Mattingly calculates across the 17 elections that he used?
Across the 17 elections he estimates a Democratic seat difference on average of 3.35 more House Democratic seats and 1.94 more Democratic Senate seats.
What is the average, if you can remember, Dr. Gordon, what is the average seat difference if Dr. Mattingly's calculation is limited to the 10 elections that the legislature used and that Dr. Chen said should have been used? And feel free to refer back to any of the exhibits we have.
Dr. Chen did not testify that Dr. Mattingly should have used the elections.
I didn't hear the objection, Dr. Counsel, respect that.
Certainly. Dr. Chen did not testify that Dr. Mattingly should only use 10 elections.
I didn't say that he said that to Dr. Mattingly. He certainly testified that he thought that 10 elections should be used because Dr. Chen used the 10 elections, and he said they should be used because those were the 10 elections that the legislature used. I am not suggesting that he told Dr. Mattingly that he should use those 10 elections.
Could you restate the question?
I will, and thank you, Your Honor. So, Dr. Thornton, what's the average seat difference if Dr. Mattingly's calculation is limited to only the 10 elections that Dr. Chen looked at?
Yes, if one limited the Dr. Mattingly's average calculation to the 10 elections used by the legislature and also used by Dr. Chen, the average difference is 1.5 House Democratic seats and 1.8 Senate Democratic seats.
So, what do those differences mean?
It means that you have a difference of up to 4.5 House seats and a difference up to a little less than 2 Senate seats based on Dr. Chen and Dr. Mattingly calculated.
And are these big differences, Dr. Thornton?
Well, I do not know if they're legally meaningful. That's for the court to decide. That's not for me to decide.
Now, from a practical standpoint, did you calculate the percentage differences between what the plaintiff's experts predict for the enacted plans versus their simulations?
Yes, again, based on those same numbers for Dr. Chen and Dr. Mattingly, the seat difference, it ranges from 1% to 3.8% for the House and a little less than 4% for the Senate.
Now, what did you find about seat shift predictions by Dr. Pegden?
Dr. Pegden doesn't calculate seat shift predictions. Instead, he's calculating, for example, if the enacted plan had Democratic vote share of, let's say, 48%, and a simulated map came up with 48.00001%, he would say that the simulated map is less partisan than the enacted map. And so as a consequence, it could be a very small fraction, and he would indicate that it is less partisan.
Now, did you calculate the number of Democratic seats that would have been won based upon Dr. Pegden's simulations?
Yes, Dr. Pegden produced code, and in his backup, he had a document that identified what certain parameters meant or could be used in his code. And in there, he had a minus sign and then a capital H. And he indicated in his description that that would produce the histogram of seats. And so we modified his command line to generate, using the minus H that he identified in his supporting document, to generate that histogram. And so we then ran it.
I want to make sure I understand this. Dr. Pegden, in his code, had the ability to generate a histogram that would show the number of Democratic seats?
Yes, based on his documentation.
And he didn't do that?
Well, he chose not to.
Oh. Can you tell the court what the results were when you performed that operation?
When we modified to include the minus H in the command line and ran it on our system, we show a seat shift difference of 4 Democratic House seats, and I believe I need to refer to my report. Three Senate seats.
Okay. Now, summarizing, Dr. Gordon, is it correct to conclude that across the three experts, the difference between the Democratic seats from the enacted maps and the simulated maps vary from 0 for particular elections used by Dr. Mattingly to at most 5 House and 3 Senate seats?
Yes.
Are those differences statistically significant?
No.
Are the reports of your statistical tests that you performed contained in your expert report?
Yes.
Did the three experts criticize you for performing the binomial test?
They did.
Why did you use the test that you selected?
I used it for several reasons. Here, as I've testified, the experts, three experts, have narrowly defined through their criteria the maps that they're choosing for their simulations. So they're biased. And so they're, in a sense, proxies. And as a consequence, we're using, I'm taking all of their simulations, and I'm calculating from their simulations the expected number of seats. I'm taking from their calculations the expected number of seats from the enacted map. So I'm taking across all of their simulations, this is what the expected number is. It's proxy data because it's not reflective of the entirety of all possible compliant maps. We know from, as I described, they've reduced the variation. So their variation is tainted. When we have two outcomes and we have proxy data, it is, in my opinion, the appropriate test to use in this circumstance.
And is this a test that's been used in legal proceedings, Dr. Gordon?
Yes, for decades.
And is this a test that's been used in voting rights cases?
Yes.
No further questions for now, Your Honor.
Let's go ahead and recess for lunch at this time. We'll resume at 2:20, and we'll proceed with cross-examination at that time.